Yes, sir, that's correct.
And it was found in the middle of the woods?
Yes, sir.
Okay. No other questions, Judge.
Does anybody on the jury have any questions for First Sergeant Cecil?
No response or indication from any juror.
All right. Thank you, First Sergeant. You may step down.
Judge, is he released from his subpoena?
Yes.
Is he released? Yeah. From subpoena. Yes, he is released from subpoena.
All right. Thank you, Your Honor.
You may call your next witness. Thank you. Brian Bunner.
Witness sworn.
Sir, can you state your name, please?
Brian Bunner.
What do you do for a living?
I work for the Indiana State Police.
Okay. You previously testified?
Yes.
You did some work on Libby's cell phone?
Yes, ma'am.
When was that?
February 15th of 2017.
Have you done anything since then on Libby's cell phone?
Her physical phone or extractions?
Either.
Yes.
Please forgive me, I forget your rank, and I'm trying to be.
It's Lieutenant.
Lieutenant.
Yeah.
Thank you. I'm sorry.
It's okay.
Lieutenant Bunner, do you know what audio output STR means in the extraction material?
No.
During a break, did you do any Google searches?
No.
Nothing further. Thank you. Mr. McClelland.
I don't have any questions, Judge. Thank you.
DOES. Anybody on the jury have any questions for Lieutenant Bunner?
No response or indication from any juror.
All right. Thank you, Lieutenant. You may step down.
Thank you.
And Judge, is he released from his subpoena as well?
Yes. And you are also released from your subpoena.
Okay.
Thank you.
Thank you.
Thank you, Your Honor.
All right. Ms. Auger, you may call your next witness. Your Honor, may we approach? Yes.
Sidebar conference conducted.
Where are we at, Ms. Auger? I think we are out of witnesses today. We may rest, we just would like to have a night to kind of consider where we are. Okay. So do you anticipate additional witnesses? If we do, it'd be very short in the morning. Is the state anticipating rebuttal?
Perhaps one, Judge. I think one for sure, but that's all I can tell you right at this moment. But he's out of town, and I guess I wasn't expecting them to rest. So we had planned on having him on Thursday.
Yeah, we had a list for tomorrow, and we thought we'd be into Thursday, so.
So we'll have to see what we can do.
Mind if I grab my list?
Oh, no.
Just 'cause I don't have it.
I have it.
You know, for us the last three would be the possibilities tomorrow, I think. Kind of just discussing them at breaks. So we're not going to call Pearson, and we're not going to call Duncan. And if you would like to call, we'd appreciate if you would, please, call Mr. Harshman and let him know that he's good to go.
Okay.
Okay.
These three.
I can call our people.
These three.
Or just text them.
We may call, and there.
I don't have a number for her, but
Oh, well, we'll take care of it.
I do for him.
Yeah.
Okay.
Yeah, we'll take care of it. The Corti. Okay. So that leaves these three. Are these professional witnesses or parties that can?
Tony Liggett, Jerry Holman, and then Kathy Allen.
Kathy Allen are the three.
Those are your three witnesses.
Which I can get Liggett and Holman here. I can get Liggett here tomorrow. He's fairly close.
He asked what time tomorrow, and I said I don't know yet, so.
Yeah, I mean, 9 would make sense.
Okay. And then you'd have a rebuttal that you'd need to get here and to get.
Right.
You start working on that and…
Yep.
We will do that right now. We planned Thursday, but we're…
Yeah, I told them.
hopefully able to get him here.
Yep.
He's in Florida, so we'll do our best. Okay.
What is today?
Today is Tuesday.
That's frightening.
Very good question. I have the same.
Today is Tuesday.
Yes.
Okay, yeah, inaudible. Okay.
So what would you expect?
Well, I mean, I don't want to wait too damn long. Get on with it.
I would expect that we would be starting
The next morning?
first thing,
Oh, yeah.
Okay.
but we can talk about
Okay.
at our next break.
Today's Tuesday?
Perfect. It is Tuesday.
I keep thinking today's Thursday.
If we get done tomorrow.
Election day, that's how I know.
We fire upon Thursday morning and get done, right?
Tomorrow is Wednesday.
Tomorrow is Wednesday.
Tomorrow's Wednesday, okay. And that, inaudible.
Yeah, I know.
I need like a little calendar, 'cause we keep asking each other, what is today? All right. Well, let's be done for the day. We'll just indicate to the jury, what do we want to say?
Well, it's 4:15, I think. I thought cross on them might be a little longer today.
Okay.
You know, because some of that got cut out. And who are you guys thinking on rebuttal? Who's coming from Florida?
Dr. Martin.
Oh, okay.
I think that's what we have coming right now. We're talking about it.
Yeah.
I know we had other inaudible, we'll see. So we're gonna talk about it tonight.
All right. Let's release them for the day, and we do our 10-minute
Wait.
dance here.
Okay.
So we can do that, talk about it.
Okay.
Okay.
Thank you.
Sidebar conference concluded.
All right. Well, ladies and gentlemen, that will be the balance of what we have for you for today, so we're gonna go ahead and call it. I know it's a little bit early, but it's 4:30 almost. So while you go on about your own business then the rest of the afternoon and the evening, please remember what I continually have told you as we part our company, that you cannot talk about the case amongst yourselves, since you will be in the company of the bailiffs and under their constant supervision. So have a pleasant evening, and we'll see you tomorrow morning at 9.
All rise.
Jury out at 4:25 p.m.
All right, you may be seated. All right. Then, counsel, if we can just briefly speak over here. Did you wish, yeah, up here real quick?
Sidebar conference conducted.
Okay. So today is Tuesday, November 5th. So tomorrow is Wednesday, November 6th.
Yes.
So you're anticipating resting tomorrow.
Yes.
And them, you will be in the position to present
Rebuttal.
rebuttal witnesses tomorrow. Then, if that's the case, then I don't know where we're gonna be at with the witnesses that you guys are gonna call, and how long that's gonna take.
We'll let them know by the end of I'm sorry to interrupt, Judge. We'll let them know as soon as we let everyone know what we're gonna do and then.
Like where you're at.
Yeah.
Yeah.
Tonight.
By the end of the evening, yeah?
Yeah.
So you definitely have 3 witnesses for sure.
Well.
No. I'm saying those would be the only 3.
Those would be the only 3.
Yeah. I was trying to eliminate the others, just so that we could get that out of the way now.
Oh, okay.
Yeah.
So potentially 3.
Yeah.
Right. And then, we have again, I still think releasing them and starting Thursday. Yeah. 'Cause that's not fair to you guys.
No.
And I don't want to do that to you, and I don't want to do it with jurors, so, and we haven't talked about how long you're asking for closing, or what the request is going to be for closing, and who's doing closing for each side.
Right now, it's me. I might talk for maybe 2 hours tops.
I mean, that's reasonable.
I think that's reasonable, yeah.
Okay. You agree with 2 hours?
Yeah, that's.
I don't know that we're going to do this, Judge, but in other courts that I practice in with my partners and others associates in my firm, we do a split close, where one does a part hal F and the other one. I don't think we're doing that, but if we
No, we're.
decided to do that, would that be something that you would allow?
As long as you're staying in the time frame.
Okay.
Yeah. I mean just because of the volume of.
You're not gonna ask the jury how long they want final arguments to be?
No.
That 2 hours, is that including rebuttal as well?
Yeah.
Okay.
So you'd have to split your time up.
Okay.
And I'm happy to give you however much time, like we did inaudible.
I mean, can we just kind of do this on a gentleman's agreement here, like we have 2 hours? If it's getting verbose, and we're completely ridiculous, you can stop us?
I'm good with that.
You want her to stop us?
I mean, you know.
The judge?
What I'm saying, like you'd call, you might say, hey, we need to move along. You know what I mean.
I'm alright. I don't expect to inaudible.
Yeah, like we're doing voir dire or something.
Bring A inaudible.
Yeah.
2 hours and 45 minutes, that's.
Yeah, if I can muster up 2 hours of energy, you should be proud of me, because I don't know that I'm going to be able to do that on Thursday.
So I'm okay with the judge doing that.
Yeah,
Okay. And that's fine.
Yes.
It's important that you guys have the time that you need.
yeah.
Make your spiel to the jury, and they're gonna want to hear your spiels, they're gonna want to hear your perspective and hear what you've got to say.
Yeah.
About the evidence.
They'd had some questions of everybody.
They'd have some.
Inaudible.
Okay.
Inaudible, security indicate inaudible.
Sure, that's fine with me.
Thank you.
I mean, assuming that they're okay with it, yeah.
Thank you.
Sidebar conference concluded.
All right. Well, thank you for that opportunity, ladies and gentlemen, to just kind of have a conversation on the record but at sidebar about where we're at with the next steps in the trial. So we'll see everybody here tomorrow morning at 9 o'clock. And I appreciate that you guys have been working well into the evening and communicating with each other very well to let each side know where the other side is, so we'll see everybody tomorrow morning. Thank you.
Thank you, Judge.
You can go off the record.
Off record at 4:30 p.m. On record November 6, 2024 at 9:03 a.m.
Well, good morning, ladies and gentlemen. We are back on the record in State of Indiana versus Richard Allen, 08C01-2210, MR1. I'll show the defendant Shear in person with counsel. State Shear by the prosecutor and his deputies. The jurors have reassembled and are awaiting our direction. Are we ready to proceed, Mr. Rozzi?
Yes, Your Honor.
Mr. McClelland?
Yes, Your Honor.
Let's bring in our jury, please. Could you turn your table mic on, Mr. Rozzi or Ms. Auger? Thank you. You're welcome. Thank you. Sorry.
All rise.
Jury in at 9:05 a.m.
Thank you. You may be seated.
Thank you, gentlemen. All right. Well, good morning, ladies and gentlemen. It's nice to see you back this morning. Gave you a minute there to get kind of all settled in, get your things ready. I think we are ready to proceed. Mr. Rozzi, you may call your next witness.
Judge, The defense rests. The defense rests.
Mr. McClelland.
Judge, may we have a brief sidebar, please?
Yes.
Sidebar conference conducted.
What was that?
I just knocked my computer down.
Oh,
Judge, since the defense told us last night they would have a couple additional witnesses, we tried to, inaudible, traveling a distance. So we think our first rebuttal witness will be here at 10 or so, and then we should be ready to go. We'll have 3 witnesses all together, Bree Wilbur, Brian Harshman, and then Dr. Martin. Bree Wilbur's gonna be our first, and she's
Indianapolis.
Indianapolis.
And I got a hold of her last and asked her to inaudible.
So they're all on their way.
Okay.
In the meantime, I'd like to reoffer the Cass County video for you to consider that evidence based off the Westville testimony about his personality, some evidence that they offered, and that's based off Dr. Westcott's testimony.
Judge, our position on that is clear that we were instructed by the court to keep this confined to that April, May, and June timeframe.
Affirmative response.
And we made a concerted effort to do that. I think the last information that Ms. Westcott said she'd reviewed was in February of 2024, which was 8 months before that. You know, there was no testimony from her, and I purposely steered away from any of the profiling or anything like that, because I didn't want, to violate the court's directions in that regard. So our argument is that, there are no facts to support that we opened the door and it's still a 403 problem. Either that, or it's a 404 problem as well.
If there was any door opening, it was, yeah.
Yeah, they're trying to prompt it by their questions, and I appreciate fully. I mean, I understand that that's the way the game is played, but the witness has been instructed to stay away from that. And in fact, even yesterday with Dr. Gracian, those were the instructions that I've given them. I said, we're not talking about any of these things, it's just the stuff that occurred in April, May, and June. And so we don't believe they've opened it. That's just not happened.
Judge, may I respond?
Yeah.
Polly Westcott specifically testified that he was fragile like an egg, passive, and avoidant of conflict. That is an impression that she left with the jury. We believe that we should be able to respond to that.
Based on, she testified around what he showed up as.
Yeah.
When first in DOC, and that was his condition when, that's what she was testifying to. Again, staying within the timing boundaries that the court has imposed upon us.
Well, and we agreed. I think the testimony was she was kind of describing his broad personality. Demure was not the word, inaudible, to this type of evidence. However, I think the probative value is substantially outweighed by the prejudicial effect on the jury to consider that evidence. I think you got there, but I think the prejudicial impact is so strong that the jury is gonna to that inaudible, and it happened while he inaudible, so I think it's relevant, but the 403 value is just it's horribly prejudicial.
Judge.
And the other issue. Oh, sorry.
No, go ahead.
On the other issues, he said Bree Wilbur was one of the witnesses.
Brian Harshman, and we're good to go, and then Dr. Martin.
Okay, so Martin's gonna be more mental health stuff, clearly.
So I hate to send the jury out.
Well, sorry, oh sorry.
What were you gonna say?
I guess I had a thought. I kinda started, so then, we would have Sir rebuttal.
Yeah.
So keep Martin here, 'cause if I get restricted, we're gonna talk about it. Then I'm gonna, call him on Sir rebuttal. 'Cause we deposed him, we know what he's gonna say.
Well, he's driving from Chicago right now. I think he left at 7 or 8, but I'm not sure if that's Chicago time or our time, so.
Okay.
I didn't ask that.
Yeah, we had an estimate of 10:30 at the earliest.
All right. Well, why don't we do this? I'm just gonna tell the jury that we have some witnesses that we need to get inaudible, and, rather than keep them waiting here, they'll just go back.
And we'll notify 'cause I'm hoping it's sooner.
Okay.
As soon as Bree Wilbur gets here.
I didn't want to do like one witness and then break.
Yeah, no, right.
Right. I'd rather do it this way.
Okay.
Okay.
Thank you, Judge.
Sidebar conference concluded.
Well, ladies and gentlemen, there are several witnesses that are not quite available yet, so we're gonna, rather than keep you waiting while we have that discussion, we're gonna give you a break. While you're outside the courtroom, please keep your minds open. Please don't form any opinions or conclusions about anything. You may discuss the evidence, but please, only do that if all 15 of you are present in the jury room at the same time, and please, don't deliberate. Gentlemen.
All rise.
Jury out at 9:13 a.m.
You may be seated. All right. So you'll let me know when your witnesses arrive. Is there anything we need to discuss outside the presence of the jury?
Nothing from the state's perspective.
No.
Judge, besides what we discussed at sidebar.
Okay.
But that's on the record, so the state's satisfied, Judge.
Okay. Could we do this? I do have potential jury instructions for counsel. Could we, perhaps, have that conversation, settle jury instructions, as least, an order of argument, and then we can await the arrival of the state's witnesses. If you'll just give me a moment, Jody's gonna go run and grab those, they're sitting on that little table, just grab the whole thing, and then we can settle instructions. I didn't receive any instructions from either side. I provided the pattern jury instructions that you are familiar with from prelims, so those should be the same as what we would be doing in finals, as well as the charging information, the statutory elements. I included the instruction, at the defense request, that the defendant is not going to testify.
Yes.
I included the prior inconsistent statement pattern jury instruction. Since we've had quite a few prior inconsistent statements, I think that would be helpful to the jury in making their deliberations. And then, the standard instructions. Jody's got your copies for you. I'm sorry, I haven't signed them. I wasn't anticipating having this discussion quite just yet, but since we're all here, let's use the time that we have. So I'll give you a few minutes to review the instructions, and then let me know when you're ready to discuss them.
Ken, are we going to take a recess?
Yeah, go ahead.
Oh, okay.
Thank you. Sorry.
Okay. I didn't want to just walk out.
No. Jody, you can go off the record while the attorneys talk.
Off record at 9:15 a.m. On record at 9:51 a.m.
All right, we're back on the record. I asked counsel to review the court's PRO-paused final instructions. I didn't receive request for instructions from either side, but I have provided the pattern instructions, which is what I normally provide to the parties. Does the state have any objection to the instructions as proposed?
No, Your Honor.
Does the defendant?
I, the judge, the PA, let me see if I can find that, whether he testified or not, that instruction, was that the pattern? We couldn't pull it up. I'm guessing it is, if you say that it is. It seemed like it was missing a part. They're not numbered yet, so, there it is. I have it as page 11. I'm sorry, we could look it up now. We were down in the basement and I couldn't pull up the pattern, but in the trials that I've been in with this, the pattern, I always remember the end part being, the defendant did not testify. You should not consider that in any way, or something like that. But I trust you, if that's what the pattern is and that's what you gave, then I don't have an objection if that's what the pattern is.
This might be a modified pattern based on prior defense attorneys' requests to explain it more.
If it's not the Indiana pattern, we would request the Indiana pattern at the page 11 instruction, starting, under the law of Indiana, a person charged with the commission of a crime is a competent witness to testify.
So you don't want all the extra language that's been previously requested by other defense lawyers. I just want to make sure I'm understanding.
I apologize,
I'll have my staff prepare one.
We'll just keep it. That's fine, Judge. I mean, I've reread it. I didn't know, it's fine. I appreciate it.
Judge, we do have. I would like, if the court would give us until maybe later this afternoon, close of business, to submit a preliminary, or a final, proposed final, on the juror's ability to judge the credibility of the incriminating statements by Mr. Allen. I don't know. That's certainly not one of the patterns, but I think there's case law that supports that. I'd like to, if the court would just give us until the end of business SS. We can email one or submit it in that manner. If we need to talk about it tomorrow, that's fine. It's not overly complicated.
So you want an instruction on?
That just instructs the jury that they are the judge of the credibility of the statements. And this goes back to our discussion before about the court's the gatekeeper with regard to whether or not they're voluntary or involuntary. And the jury is entitled to judge the credibility of the witnesses. I'm kind of doing this, winging it a little bit, I apologize for that. But I think the Stanger case, SDNGR, is one of the cases, and I'm asking for just a little bit more time to offer that up to the court.
Does the state know what he's referring to?
I don't, Judge. Just a preliminary review of the instructions. I think credibility of a witness is addressed in the instructions. I think that would be sufficient. But I'm not familiar with the Stanger case, Judge.
So you'll have that by the end of the day?
Yeah, I can get it by the end of the business, that's fine. Is it okay if I just email it to the court and copy Mr. McClelland?
That's fine.
And we can talk about it tomorrow, if needed. Okay, I don't have anything else, Judge.
Thank you.
And I've had my staff, then, send me the actual pattern without the extra language on the defendant not testifying, and then we can discuss that one, as well, if you want to have those read.
Thank you, Judge.
Or one or the other. All right. Can we talk about order of argument before we recess, then?
Yes, Your Honor.
The jury rules give the court the authority to instruct the jury with case-specific instructions, after which counsel make their presentation of their final arguments. At the conclusion of the state's rebuttal, the jury rules give the court the authority to give them, then, the balance of the instructions, which are the general instructions at the back of your packet on how to weigh the evidence and how to conduct their deliberations. I've been doing that since the jury rules changed 10 or 15 years ago, permitting that type of presentation, with the understanding that I think it does help the jury as they're listening to your final arguments, that they have the specific framework of the law as it relates to the charges, the statutory elements, the definitions and all that goes with that. That's been my practice for 15 years since that changed. Does the state have any objection to that?
No, Your Honor. No objection from the state.
Does the defendant have any objection?
No.
Okay. And I know we talked yesterday about the length of argument. I'd initially said 2.5 hours. You guys seem to think that that's gonna be sufficient for you, and you'll monitor your time. Obviously, if it goes much past 2.5 hours, I might be clicking a pen or tapping to kind of go, hey, can we win things up here? But you've presented a lot of evidence to this jury, they've had a lot of witnesses testifying. I want to make sure you have all of the time that you both need to present your argument. So does that accurately reflect our conversation yesterday about the length of argument, Mr. Rozzi?
It does.
Mr. McClelland?
Yes, Your Honor.
So, and if you change your minds about a warning salvo, I'm happy to just say, could you please wrap it up? I don't want to cut you off midstream.
Yeah, I understand that.
But if it becomes an opportunity to just kind of remind you gently of the time frame. I know, as a former trial attorney, you kind of get going and lose track of time, so I know there's a clock right up there, but we're not watching the clock.
Well, there's a pointer stick over there on the table. I'll give that to you, and you can prod us. I think we'll be fine. I think Mr. McClelland and I had a conversation yesterday that we would do this on a gentleman's basis, and, kind of 2.5 hours would be that.
All right. So.
Period, and I think we'll be able to deal with that.
Will there be a break between?
There will have to be.
Yeah.
When the statty finishes its preliminary argument, we'll take a break, the defendant will then present his preliminary argument, and we'll break, and then the state will have the opportunity to present its rebuttal, and 2 hours is a lot for these folks to be sitting in these really uncomfortable, hard chairs, so I think it would help them to have the opportunity to refresh themselves a little as they then anticipate the next argument, so yeah, we'll be taking breaks.
Okay.
Judge, I may just use this table and maybe move it over a little bit. Maybe closer to this line. If that's okay with the court. I could anticipate that happening.
Oh, putting your things on the table.
Yeah, maybe because.
That's fine. Or you can move that big old podium, however you want to do it.
Okay.
Just make sure to give the jury plenty of personal space, so they don't feel crowded.
Okay.
All right. Anything else that we need to talk about before we recess and go off the record? No? All right. Jody, you can go off the record and we'll be in recess until the state lets us know where we're at with witnesses.
Thank you, Judge.
Off record at 9:59 a.m. On record at 10:25 a.m. Sidebar conference conducted.
We were up talking with the staff and they told us, when we broke out with the instructions, they were still fully 40 more minutes out, and so.
Well, we were just told 5. Are your folks here?
Yep.
Oh.
We've got everybody here.
Okay.
But we can wait however long.
So I told the jailers, so they took Mr. Allen downstairs.
Oh, all right.
And Mr. Baldwin ran back to Logansport to get some notes.
Everybody sure.
That's what we were told. I was listening to what? I'm not saying anybody misrepresented anything, but I talked to Trooper Holman, and that's what he told me, so.
Okay. Well.
I don't know what else to do.
I did tell him about a half hour, but we got everybody here. So I talked to Mr. Rossi that we've got our witnesses here. We can go whenever.
Well, I'm just call. It's not going to be hard to get Rick back up here, obviously.
Oh, right, he's just downstairs.
I just didn't want him sitting in the courtroom. These guys are like, what are we doing? So I just told them what I was told.
Affirmative response.
They made their decision, so really?
Inaudible.
Let me do that. Let me just step out and see what we can do.
Okay.
So.
I just ran downstairs. Okay.
That's okay.
All right. Go call and get Mr. Allen up here.
Okay.
Off record at 10:26 a.m. On record at 10:30 a.m.
It's still going to be 25 minutes before he gets here. They're hustling. I don't know what else to tell you. We're just trying to work within the time frames we were given, so.
All right. Well, we can't do anything if your co-counsel's not here, so I guess we'll go off the record.
I'm sorry. I just deal with the logistics.
All right. Well.
Sidebar conference concluded.
Sorry, ladies and gentlemen, we have no attorney here to conduct cross, so we'll have to again go off the record. Jody, you can go off the record.
Off record at 10:30 a.m.